I had an individual come to me in 2015, out of the blue. He receives a letter from the federal government telling him that he's a target of a criminal investigation. The case was an antitrust matter. Very large investigation. He did not appreciate it at the time. He was retired. His kids were getting older, college age, high school age, very involved in them. They were athletes and whatnot. And out of the blue, he gets this letter. And of course, we learn his story. I believed in him wholeheartedly. He believed in his innocence wholeheartedly, and that there were individuals to protect their own interests had pointed the finger at him. But it was going to be a long and uphill battle. And I met with the lawyers from the Department of Justice Antitrust Division in New York who were prosecuting the case and tried to persuade them not to indict him. I went to the Department of Justice, Main Justice in DC, pleading his case and his innocence. Obviously, as I delved into it and got to the bottom of it, there was about 7 million documents for us to review in the case. It was a large matter. Unpersuaded by our pitch, they indicted him, and we were facing trial. And you had to, part of it is the technical, mechanical work of being a lawyer and doing all the things necessary, reviewing every document, going through every email with him. There was 100,000 emails alone probably in that case. Winnowing that down to the important stuff, developing a timeline and a story that supported his based upon the documents in the case and his lack of knowledge as to what was going on. He was, emotionally, you have to let your client know. And I think if you say, Robert, does something distinguish you between other lawyers who do this work, right? Because there's many of us who are skilled at this. I let the client know that I stand between him and his problem. I stand between him and the Department of Justice, for example. I stand between him and the judge who may ultimately sentence him or preside over that trial. I stand between him and a jail cell door. And I take that responsibility very, very seriously. That means that we don't do anything, that jail cell door will never close unless I've done everything in my power to prevent that from happening. And in a case like this, it made it more difficult because I did believe in him. It's easier to have those discussions of making a plea deal, something that's in, maybe your client's better interest in trying to talk to him or her about that. But in this case, he believed, I believed. So we were locked in. And we made discovery demands and made motions. Might have been a little unconventional, but it proved to carry the day. Ultimately, 6 weeks before the date of trial, which means you are heavy involved, the government dismissed its case. And I have had probably no more rewarding feeling and no more pressure than I've ever had on another case. But I think through those experiences, it helps you approach the practice of law, approach the defense of your clients in having gone through those experiences.